Good morning, everybody, and welcome to a webinar entitled Finding a Transverse Path Over the PHE and What to Do If You Cannot Find It. With me today is my partner, Larry Gill, and our other partner, Mark Hardiman, has to make his apologies. He was scheduled for a deposition after we had scheduled the webinar, so he can't make it, but we'll tease him later about we didn't need him anyway. We are in the middle of a weird business situation where you've got Wall Street and the investment community seeing through the pandemic to a vaccine, and then making investment and business decisions for the S&P 500 type of companies basically on a 2022-2024 time frame. Meanwhile, Main Street, all over the country, people are in dire shape if you're in the restaurant business, and hurting if you're in healthcare. As you know, healthcare has kind of had the strange situation of gearing up to treat COVID and then kind of shedding everything else. And as a result, a lot of major healthcare institutions are hurting. They got rid of all their outpatient business for a while. They converted everything to COVID treatment, and people naturally chose not to go to the hospital if they absolutely didn't have to. And so hospital volumes are down. Expenses are up as major influx of personal protective equipment buying came through. Individual doctor's offices, some are busy, some are not busy at all. Many have transitioned to telemedicine, trying to offer at least some service. So we're going to discuss what to do if you are a business on the distress side of the ledger. And we're going to talk about capital raising, workout, bankruptcy, and liquidation. Next slide. So disclaimer, this is not legal advice. We are going to point out some of the legal pitfalls in each of the areas that we are going to talk about. But in order to get legal advice, you have to retain a lawyer. And this is only the discussion purposes and informational. Next. So the public health emergency, it is going to last until the vaccine is deployed, or we're lucky enough to get a therapeutic regimen sufficient to prevent death, and then the world will ease up. The likely transmission of the disease is going to be waves and regionally contained. In California and Florida, we're in the kind of huge wave that New York and New Jersey saw early in the year, and it's just going to keep going around. It does not appear to be seasonal and seems to spread based on social interactions regardless of climate or ambient temperature. It's just not going to go away. Next slide. So despite government support, thousands of healthcare businesses are victims of PHE one way or another. And so we do believe that there's going to be tremendous reorganization in healthcare with mergers and workouts, permanent closures, and some liquidations. And so what has happened in the healthcare space specifically is that demand for healthcare services has been slashed, unbelievably so. And then what demand has continued has moved substantially to telemedicine platforms. And then the epidemic has also put additional costs in handling the non-telemedicine demand. So the business models have all been turned on their head. Next slide. And we don't think that people are going to change back to the way it was. What we've seen from behavior changes, and we pointed this out in our last webinar, is that Hong Kong has had virtually no COVID. They've had 7 deaths versus New York City's 17,000. And Hong Kong, if anything, is a more dense city and of similar population. How is this so? Well, it's so because SARS so scared Asia at the 2002-2004 outbreak. They were prepared, and immediately upon hearing of the COVID, started social distancing and masking, and they did not have an interruption of their economy. They are just used to being masked and distancing, and so that substantially stopped the transmission of the disease in Hong Kong versus other cities. So we think that as slow as we are to pick up in America on some of these things, that there will be a tremendous demand for telemedicine that will continue. And we also think that there will be demand for different patient flow at healthcare institutions, such that you'll stay in your car before it's actually time to see the doctor. There'll be lots of in-between patient cleaning, and this will be the norm going forward. So your cost of operations are going to stay higher than they were. Next. So getting down to brass tacks, my business in distress, now what? And you know, it's reality time. The best first step is a realistic assessment whether you can bridge across the public health emergency. Are there cost savings to be had in the operation of your business? What other sources of demand for your services do you have? Do you view what you want to be doing post PHE when the vaccination is deployed? Businesses with healthy balance sheets may just choose to curtail operations for a while and not deploy their balance sheet strength just because they have it. Even as the liquidity crisis for most businesses has been eased by PPP and other programs, you need to assess whether drawing down on lines of credit and using your balance sheet makes sense in the long term. And in some cases it might, some cases it might not. It might be better to interrupt temporarily than to continue. Next. So I think that's where we start, is an assessment of your post-PHE goals. Gauge your true time horizon. Also figure out, you know, if you do tap resources, you do borrow more, or you change your obligations on your lease to trade some rent payments now for an extended term. You need to make sure all these match your business goals. So it's very important to have the long-term macro goals in mind before trying to chart the path across the PHE. And also, we all have to anticipate a reduced profitability. Tax increases are very, very likely. If Biden wins, he'll definitely raise taxes. And even if Trump is reelected, we believe the Republicans will return to more budget balancing mentality, and they will raise taxes to some extent. And then tax increases for struggling states and municipalities are also likely. So we just have to figure that the net to our pocket is going to be pinched down 10 or 20% in the next 5 to 10 years. Next slide. So gaining liquidity is the next important tool to bridge through a down revenue time frame. PPP was designed to do that, and they were hoping to get to the summer and then let COVID go away, but it didn't. And so now there's a big discussion in Washington about additional rounds of PPP or other relief for Main Street. The Republicans have proposed about a $1.3 trillion plan, and the Democrats proposed a $3 trillion plan. And you would think they could, you know, add a little more to the Republicans and get the Democrats to support it, and we'd be done with it. In the meantime, the support ended July 31st, and we're now in the 12th day of August, and so there's going to be, I think, enormous political pressure on both parties to get a deal done. It's taken longer than many had hoped, but we do think there will be additional funds available, probably mostly for individual workers, not so much for businesses, although business relief is still out there. There's still a lot of unlent money from the round one, especially for healthcare. There's reportedly $175 billion at the disposal of the Treasury for healthcare that has not been dispersed yet. So we think there is some liquidity availability still. Lending sources can also be from traditional sources and others, such as investors, you know, getting very little from banks, but maybe getting 5 or 10% from a small business would be an attractive use of their money. And then certain businesses can engage in capital raising, you know, sell stocks, sell equity. And so it's another possible avenue, is to give up some equity in exchange for liquidity to bridge yourself over the PHE. Next slide. We get a lot of questions about business interruption insurance, and yes, it's out there. Yes, you may have that coverage, but it's something that you have to look at very closely in your policy, and you do need to seek legal counsel on the ins and outs of insurance policy interpretation. to gain a better understanding of your chances of really receiving relief here. The insurance industry has been anticipating a pandemic for decades, and most policies we see have a pandemic exception to business interruption insurance for the very reason. And they're aggressively defending claims rather than processing claims, as we've seen. But that doesn't mean you are without a remedy, because you could argue that you didn't lose business and your business wasn't interrupted because of the pandemic directly. It was because of government orders. And so the government order of your business to cease for a period of time may in fact fit the contours of your insurance policy. Also, what is a loss? Did you have to go out of pocket, or is lost revenue versus a prior time frame sufficient for a loss? That's also an issue in policies. And then business interruption. Let's say you're a hospital and you shed outpatient and it went to zero, but you had inpatient, you continued along. Does that temporary impairment of your outpatient business constitute business interruption under your policy? That's another issue you looked at. And finally, you may have every reason in the world to stay open. You may have absolute demand, but because of the structure of your brick and mortar office or business structure, you can't really comply with OSHA worker safety requirements. You may not have the ability to get your landlord to put in UV filtering on the HVAC system. So it may be OSHA regulation required your business interruption. So those are all issues for consideration, and you should consult your attorney on that to see if that's available for you. Next. So capital raising, there's lots of ways to do it. We do a lot of private placement memorandums under Regulation D. If you have the low and mid cap markets, that's a typo there. Regulation A, crowdfunding offerings, Regulation A plus. There's lots of hybrid for liquidity and capital raising as well. Promissory notes, convertibility features, options, buy-sell arrangements. So there's all the tools in the bag are available to raise capital from investors. The trick to all of them, though, is convincing investors that your business is worthy of the investment, that you've got a return, you've got a business plan, you've got a good 5-year outlook, and you can make good on the investment and provide the returns the investors are looking for. And this may not be realistic for a business that's distressed in some part, but it should be something you think about. Next. So let's say you just don't have liquidity. You don't have a credit line you want to tap. Capital raising is just out of the question. Your business interruption insurance did have major exclusions, and you can't push through that. You've got some support from the government, but basically liquidity expansion is not very available to you. So then you have to go to the cost side of the ledger. And these are things we've seen, of course, in all sorts of businesses, especially in healthcare. Furlough, portion of the workforce, try to negotiate, reduce rental payments, reduce your hours of services, to reduce your cost profile. And then, demand expansion, move to telemedicine, try to see if a larger business needs your support. Look at new modalities and new services that aren't as impacted by the PHE. Next. So, getting down to some practical applications of how to maybe push a few levers and gain a bit of a margin or get back to break even. So the scenario A we've posited here is a longer time horizon and some liquidity, some ability for cost savings, some ability to maintain demand for services. What do I do? So again, carefully run the numbers and assess what's really doable. Leave no stone unturned in doing that. But these are the contours of what we call a functional workout. Not a lot of legal stuff going on here, except you need to approach your stakeholders, your landlord, your vendors, your employees, and see what concessions you can gain from each. Try to lower rent, defer maintenance costs, furloughing non-essential staff, working with lower price vendors, and then looking at the structure of your business and how you approach the marketplace, whether you need your brick and mortar, whether you can approach the marketplace through a telemedicine platform. But the key to a functional workout is figuring out what concessions you need to get by and then tap only as much of that as you need every month to keep your business open. So there's not a lot of formality here, but you know, in many instances, you can find enough flex from stakeholders to provide yourself with a workable margin while we all wait for the vaccine. Next. So again, you're trying to press as many levers that you have at your disposal. It has the benefit of not requiring a lot of legal entanglement and working for temporary relief to get distressed business through the PHE. And the concept is, you know, if you like me as a customer, give me a better price, and I understand once this is over, we'll return to business normal. You may have to raise the price back, but you know, give me some help now. And you make that kind of approach. Next. So what happens if you're in great distress? Your liquidity is limited, your ability to cut costs and keep providing service are not very good. So there we may be looking at a formal workout. Under a formal workout, this does require some legal assistance in most cases, because basically you're going to your landlord and your vendors and other stakeholders and saying, listen, my next stop is the bankruptcy court or a complete shutdown. And, you know, unless I get some very substantial help, I'm not going to get the next year. And so I don't want to, you know, screw anyone over, but I need the assistance to keep, you know, the lights on, and so here's what I need from you. And again, it's a lot of homework ahead of time to understand what you need to get from here to there in terms of dollars, and then looking at where those dollars may come from. And it may not be comfortable for you to approach the stakeholders and make the suggestion that, you know, I need some help here. But this is how a distressed business in normal times, you know, gets through to their next phase of operations. Whether it's scaling down or you know, recapitalizing eventually, but you need absolute help from vendors and landlords and others. And so you knock on the door and you say, listen, I've got a proposal for you. You know, it could be as simple as you don't charge me rent for the next 2 years, and I'll add 2 years higher rent to the end of my lease. You know, there's lots of different ways to do it, but it will require documentation and some degree of formality, where people have to understand their rights under their existing documents. You know, work with your bank to get time to pay back lines of credit, work with your landlord to get, you know, reduced rents, work with vendors to get significantly lower prices, but don't have vending interrupted. But all these are going to be contractual in nature, because the vendors aren't going to make substantial concessions, and you may need them without, you know, knowing what the trade is going to be fully. So this is a more formal approach to the, you know, the same sort of effort to get a workout, but you have to be, you know, in a position where you can demonstrate that, you know, the next stop is shutdown or bankruptcy, and so everyone's just better off if everyone, you know, gives some here, and you know, you can work in a break-even business for a few months until the vaccine comes. Next. So expect requests for substantial concessions post-PHE if you go knock on the door and ask for a substantial concession now. Make sure that you stay within the parameters of your requests. Expect some legal costs for documentation of amending contracts and loans and leases. And make sure, we think our one legal tip we will give here is educational advice, is that the PHE end isn't going to be a fixed hard date. Well, the federal government will, but you know, there's going to be a feathering period. The vaccine will be available later this year, but you know, 300 million people aren't going to be vaccinated by January 1st. That will take, we think the vaccine won't be widely available until May of the coming year. Hopefully that's, you know, worst case scenario. But the bottom line is you should have, you know, some negotiation of what the reversal of the concessions looks like, and make sure that there's 90 or 180 to feather that out. So you don't want to have a hard end of the PHE. You want to have kind of a graduated return to normality on the post-concession period. So, you know, taking the instance of a lease, maybe you pay no rent until May, and then you pay half rent for the rest of 2021, and then you have a rent increase in 2022 to, you know, start making the landlord whole. So something like that just doesn't, you know, slam the brakes, because the demand's not going to return in the same fashion immediately, even though the vaccine is out there. So you have to anticipate that and give yourself recovery time frame beyond just the concession period. Next. So now, Mr. Gill, who is a former bankruptcy partner, and then went off and ran his own hedge fund that dealt in distressed debt and knows everything about bankruptcy left and right, is going to discuss, let's say concessions aren't forthcoming, people are not being helpful, and you've got bills that are due, and people are starting to, talk about exercising their security interest rights. What do you do then? So Larry, why don't you discuss Chapter 11 and 7 and everything else?
Rob, thank you very much, and I appreciate everyone being here today and having the opportunity to speak here with you all. As a prefatory matter, we don't say ex-bankruptcy lawyer, we say recovering bankruptcy lawyer because it's one day at a time and it's never going to go away. In a nutshell, we could speak about bankruptcy for a long time, and this is one of those areas of law that filters all other types of areas of law because it deals with the insolvency issue. So what I'm going to give are sort of a broad overview of the basic parameters of what you can do and you cannot do or should be careful of in the bankruptcy process, and then address some specific issues as they pertain to healthcare businesses. Rob said that your best option in a situation of significant financial distress is to reach a voluntary workout, reach an agreement, and that is absolutely the best way of obtaining a good outcome. What happens, however, when you have some of your creditors or some of your vendors who just are the holdout? They don't want to sign that deal. They're not interested, or they're asking for more than you can give or than you're willing to give. Well, the bankruptcy option is designed exactly for that holdout problem. As long as you have certain legal steps fulfilled, you can force a solution upon objecting creditors and objecting vendors. As you can hear from that language, it's inherently more difficult and not the ideal situation, because in order to have a business going forward, you'd like to have voluntary buy-in. But that said, as you all know, sometimes that's just not available. The basic, overview, when you say bankruptcy, it actually entails three very different circumstances as it pertains to healthcare businesses. Chapter 11 is the one that you're probably most familiar with, at least hearing about. The notion of Chapter 11 of the Bankruptcy Code is to reorganize a business. The classic idea is you have a good business and a bad balance sheet. And so therefore, if you can reduce the amount of debt you're paying, fix some contracts that may be overly burdensome to the debtor, and just have some breathing room, from the court, or I should say provided by the court, a little breathing room from your vendors and your creditors, you can fix all this. That is a significant and a huge part of Chapter 11, but modern Chapter 11 practice is not limited to reorganization. Fact of the matter is that even if you've decided that the only way out of your particular quandary is to sell the business, either as a whole, as a going concern, as a sale of assets free and clear of all liens, claims, and encumbrances, or just liquidate, even, burn the furniture. Most people running a business will recognize that the best way to do that is to take charge of an orderly process. And you can do that under Chapter 11. And it has increasingly become a very, oft used format of the Chapter 11. And instead of a plan of reorganization, you see plans of liquidation. They usually come after an engineered sale of all the assets of a company free and clear, but still it's done in a way that should keep costs down. We'll get to costs, however, because they're a huge component of the notion of whether the bankruptcy process is even feasible for you. Again, in sum, you have Chapter 11 that is either a reorganization if you have that good business but that bad balance sheet, or if you really need to sell and you can still sell in a way that makes more sense. For example, if you take the time to wind down your own accounts receivable, that might maximize the value. There are all kinds of reasons why a liquidation plan rather than a fire sale is going to end up being advantageous, not just to the debtor because the costs are down, but actually to those other parties in interest, the creditors and the vendors. Now, Chapter 7 is the option that you go to when you have no more options. In a Chapter 7, as you probably know, and I apologize, you might know this is a broad explanation, but I'm going to do it anyway. And if you have any questions, of course, you should be noting them, and we'll have time afterwards as well. In a Chapter 7, the court appoints a third-party trustee, an independent trustee, who becomes the representative of the estate being all the assets, real or potential, that were held or potentially owned by that debtor on the date it filed for Chapter 7 protection. That trustee's job is to sell everything it can, and as a debtor, you get to retain what you're allowed under state law as a statutory exemption. There are exemptions for homestead. There are a list of exemptions in the UCC, in the Uniform Commercial Code, but everything else gets sold and it gets distributed to creditors pro rata. You can't prefer one creditor over the other if they have the same legal rights. If they're all unsecured, everything gets pooled, and if there's only enough to give 10 cents on the dollar to everyone, then everyone gets 10 cents. You can't give 50 cents to one and then 2 cents on the other. Now, very interesting here on this slide, the latest creation of the corporate bankruptcy world is the new subchapter 5 of Chapter 11 reorganization, which is becoming a powerful new option. And in the wake of the COVID pandemic, it is becoming even more used, utile, and popular. What we're talking about in subchapter 5 of Chapter 11 is, if you're familiar with Chapter 13, which we're not really going to talk about because Chapter 13 is for personal reorganization plans. It's if you're an individual, not a corporation, and instead of liquidating, you think that you can get through this if the court sort of oversees your payment plan. So subchapter 5 is basically that for a corporation, and it has a size limit. If the corporation has total debts no more than 7.5 million, then it can utilize subchapter 5. And what subchapter 5 is, rather than having to negotiate a plan, which we'll talk about, but a plan is a heavily negotiated contract that's between the debtor and basically everyone else in the world, all creditors, all vendors, all litigants, everyone else you can list. This is a pre-structured, formatted plan that basically says that the debtor is going to have 3 to 5 years to operate and use the cash that it generates and pay back all of its creditors, including lawyers and financial advisors, which is a big difference between this subchapter and ordinary Chapter 11, where the lawyers and the financial advisors have to be paid on the day this plan goes effective. So we'll talk more about that as well. But subchapter 5 is really a powerful new option in the hands of a small to mid-sized business who thinks it can fight its way out of this, but just needs some time. Let's go to the next slide, please. So the very basic benefits of the bankruptcy process are the same in Chapter 11, Chapter 7, Chapter 13, Subchapter 5, and all of the other chapters that we're not going to talk about. First and foremost is the automatic. The automatic stay is a force field, basically, that gets put around the debtor on the day of the filing, and in fact reaches back 90 days before the day of the filing. If there is a pending lawsuit, if there is a pending foreclosure, any and all actions are stayed. And if any creditor or vendor violates that stay, there are significant penalties, including criminal under some circumstances. So this is a huge benefit of the Chapter 11 process, of the bankruptcy process. You get automatic stay. Just to name a few of the many, many powers that a debtor has in bankruptcy, if you have contracts or leases that are still ongoing, and they're not just money claims, but there are still obligations on each side, on the debtor side and on the non-debtor side, those contracts and leases can be looked over to see which ones are advantageous and which ones are not, and the ones that aren't advantageous can be rejected, simply rejected, say we're not going to be in this anymore. That results in an unsecured claim that the non-debtor party has, but usually that's not a good option, or it's strong leverage if you're the debtor, because in many of these cases, unsecured creditors just aren't getting very much value on the back end of this. So that's a very powerful tool that would enable you to renegotiate terms of a contract. Well, I can't do your deal, Mr. Vendor, so either I'm going to reject it and you're going to have a claim that you're going to get 10 cents on the dollar on, or you can change my terms from net 30 to net 90 and we can go on our merry way. That is a very, very a strong tool. And it's there for contracts and leases. Very important, very, very important tool. As I've referred to, if you are an unsecured creditor in a bankruptcy, generally you're looking at, and there are exceptions, but generally you're looking at significant haircuts on your recovery, and anything that the debtor can offer as a potential enhancement to a recovery 2, 3, 4 years down the road. Usually it'll be worth it with unsecured creditors. Not always, but usually. So it's very strong leverage, which is why in a standard Chapter 11 case, the court will usually appoint an official committee that's comprised of the largest unsecured creditors, because each unsecured creditor would have to spend so much on a lawyer. It would be manifestly unfair. I'll tell you, the debtor still has a significant advantage over unsecured creditors. Let's say it's unfair, not manifestly unfair. And finally, secured creditors. Now, as you might imagine, the biggest protection you can have as a creditor is to have collateral, and the biggest issue you'll have to deal with as a debtor is your secured creditor and their rights in that property. The bankruptcy process really does, however, provide some significant tools, even against a secured creditor, that a debtor can use as leverage. Just to name a few of them, as soon as an entity files bankruptcy, a creditor who has a claim that's secured by collateral, at that moment has 2 claims. It has a secured claim up to the actual value of that property as of the filing, and an unsecured deficiency claim in the amount of the remainder. If the valuation moment is not advantageous to that creditor or just for that asset, that means that a secured creditor who thinks that it's fully secured might be minimally secured, and that is a significant hammer that a debtor can use. So for example, you might say, look, if you agree to this plan to be paid over 10 years instead of the 2 or the 1, we'll give you the whole claim and we'll add some interest in order to pay for the time value. If you don't, no problem. We'll bring an independent valuation person in right here. We'll value this property, and your secured claim, it'll be the value of the property. Everything else is unsecured, and you'll get 3 cents on the dollar. That is not an easy process, and it costs money because you usually fight it out, but it is a huge, huge hammer in the hands of a debtor. You'll hear about crammed down plans. That's a plan of reorganization that gets crammed down upon an objecting secured creditor. This is what we're talking about. It's nasty and it's ugly and it's expensive, but at the end of the day, secured creditors must pay attention to it. It's a big weapon. Next slide, please. Okay, so why not just file bankruptcy right off the bat? Because it's so easy. A lot of good reasons. First of all, and it's not on this slide, remember that filing a bankruptcy, for filing a bankruptcy, insolvency is a prerequisite. So you might be in bad shape and in distress, but if you're not insolvent, and as you know, there are 2 insolvency tests. You're not able to meet your debts as they come due, or your balance sheet is upside down. But you really have to be insolvent. If you file a bankruptcy as a tool to sort of put leverage on someone and you're not insolvent, that's potentially a criminal offense under the bankruptcy statutes. So that's something that people sort of glide over sometimes. It's not to be glided over. It's very, very important to remember that. You can't just decide to file bankruptcy if you're not insolvent. Setting that aside, the biggest issue, assuming that you are insolvent, is that Chapter 11 is massively expensive. It's massively expensive, and this is something that not everybody understands. You think I'm bankrupt, it's going to be fine. No. The lawyering, the financial advisors, the court costs, it's a very expensive process. And in fact, as we'll get to, this particular hurdle, this barrier to entry as far as access to the bankruptcy process, is the primary reason why the legislature created Subchapter 5, because it was really unfair. You could only really utilize the Chapter 11 process if you had a lot of money to pay lawyers. That's number one. And that expense in a vanilla Chapter 11, and I say that as opposed to the Subchapter 5, means that really what you need to do is to go into a bankruptcy having a deal with at least the key creditors, because if you go in having no deal with anyone, that's what we would call a free fall bankruptcy. And the percentage of free fall bankruptcies that start as Chapter 11 and end up Chapter 7 is something in the 95% range. They don't work. You need to have a deal with the big secured creditors. And most importantly, if you really are going to reorganize into Chapter 11, you need one of those lenders or a new third party who's going to come and give you new money. You need that new money to pay these lawyers and to pay these financial advisors and to make sure, it's a very expensive process. It's a fact of the bankruptcy world. So that's number one. I mentioned to you the strong power of the ability to reject executory contracts and unexpired leases. Those are leases and contracts that are still running, that there's still obligations from both sides. The debtor, of course, can assume them as well. And of course, a debtor will want to, because certain contracts are vital to the operation of a doctor's business, of a healthcare business. But in order to assume an executory contract or an unexpired lease, you got to cure all the existing defaults, which means whatever has been slow paid or not paid, unless the contract party agrees to different treatment, it can object to the assumption of its contract on the basis that you're not being made whole on the day that the plan goes effective. That's something you can't just make that go away unless you have an agreement. And in order to have that agreement, there needs to be incentive to the contract party. This, just as a sidebar, all of these things will tell you that the bankruptcy process is really designed as a mechanism to foment agreement, to foment a settlement of these issues. That really is the way. It's true that the debtor has massive powers, but at a certain point, those powers run out. Under the Due Process Clause of the United States Constitution, you can't just take property away from any one creditor. The Bankruptcy Code does pretty darn close, and it's pretty frustrating to a lot of creditors and of vendors, but at a certain point that ends. Another problem with Chapter 11 is the potential loss of control. Now, when you file Chapter 11, the default is that the debtor stays in possession of its own assets and its own business and will continue to run it, and that happens 90% of the time. If, however, the management of the company is not doing a good job, you are exposed to the court and a creditors committee and the United States trustee, which is the Department of Justice arm that is assigned just to monitor bankruptcies. Someone can move for the appointment of an independent trustee, which takes you out of the picture altogether. And as someone running any business, that's just not a good option. In the circumstance of a healthcare business, it becomes very, very difficult, especially when we start thinking about what happens to a professional corporation if the ownership changes. Those laws don't change. They just sort of get they're sort of put on hold for a while, but the ownership restrictions stay in place. The Bankruptcy Code does not change state law. It works with state law. And then finally, the one that I think is probably most obvious to the people on this call is, how is the filing of a bankruptcy just reputationally going to hurt the business? Is someone going to want to bring patients or clients into a healthcare business that is in bankruptcy? Could be the answer is, doesn't matter one bit. Sometimes the answer is huge. That's something that is a threshold matter that needs to be thought about. Next slide, please. So this new Subchapter 5, it's a very powerful option. The eligibility was, I think at the outset, this was passed by the legislature about a year and a half ago. And the original limitation on the debt, held by any debtor using this subchapter was, I think, in the 4 range. The CARES Act raised that limit, obviously recognized that there were a lot of healthcare businesses and a lot of businesses, period, that would be impacted in this public health emergency. So the limit on the debt of an entity utilizing this has been raised to 7.5 million, which is great news, because this is a much more streamlined, very much less expensive process, and therefore much more feasible. This, as I said, you don't have to spend a massive amount of cash devising the plan, because the plan is sort of cookie cutter. The plan is basically you're going to run the business, you're going to take the debt, you're going to spread it over 3 to 5 years, and you're going to pay it back, utilizing the cash flow, the free cash flow that you have. And the court will talk about what's free cash flow, what are expenses, but that's really, that's a fraction of the amount of time you would spend in a detailed feasibility analysis of a Chapter 11 plan, which is a massive endeavor. It's a straightforward plan. It saves money in at least 2 other very important ways. In a standard Chapter 11, it's a long process because you have to come up with a disclosure statement. The disclosure statement being the analog to a prospectus, out of bankruptcy. It has to have adequate disclosure, adequate information to every creditor and every potential creditor as to what the plan is going to say. There's a significant hearing, usually 2 months, that gets spent on whether the information in the prospectus and the disclosure statement is sufficient. Once that's done, then the disclosure statement gets submitted, and then there's another usually 60 days in which the creditors who are impacted by the plan review the plan and have a chance then to vote on whether they approve the plan or not. And then after those votes come in, there's another 30 days at least in which the court has to be shown by whoever the plan proponent is, usually the debtor, whether that plan in fact complies with the litany of legal requirements that have to be adhered to. It's very, very long. It's very, very expensive. In a Subchapter 5, they've merged those two, that the plan and the disclosure statement process are one hearing, and the entire process is 90 days. Now, that can be extended, but the point is that you can do it very quickly, which saves millions of dollars, literally millions of dollars. The other huge concession that the legislature recognized, and it's, I'm not proud to be the lawyer telling you this, but in a Chapter 11 case, a plan is not confirmable unless every single lawyer, financial advisor, and anyone else who is afforded statutory priority is paid in full, 100 cents on the dollar, on the day that the plan begins to be administered. That is a huge hurdle, and for that reason alone, you see so many Chapter 11s flip into Chapter 7 because they just don't have sufficient cash to do it. Subchapter 5 removes that requirement, much to the chagrin of many lawyers who are short-sighted, because this is a great avenue, and I think every lawyer who practices bankruptcy should recognize it. Administrative expenses can be lumped with the other debts and paid over time, which makes a lot of sense if it's a small enough business, and it really is a significant aid to the feasibility and the confirmability of a plan. There is, in a Subchapter 5, automatically a third-party trustee appointed, which sounds like it's terrible news, but the function of the trustee in a Subchapter 5 is very specifically limited to just negotiating the final deal with the creditors in this sort of pre-formed plan, which can be, it's like having a mediator, except a mediator who represents the estate. So it's again, very, very much worth it. We're still testing out our new Subchapter 5. Haven't been a lot of cases I've been involved in, but early returns here are that it's very favorable. Another very interesting point here, and this will go on the next slide too, but one of the big hurdles to filing any bankruptcy in order, if you have a big debt, if you have something that you're trying to avoid and you can't pay because of the public health emergency, say, oh, I'll file bankruptcy and it'll go away. As people on this call know, most of these types of debts, whether it's a piece of equipment, an MRI machine that is being leased from an equipment, leasing company, or a body sculpting machine, or any of these, most of the leasing companies are going to require personal guarantees from the principals of the entity. Those guarantees do not get discharged in a bankruptcy. And that is just so important to know. That's something called the independence principle, which goes back to, I think, Mary Yield, England. The personal guarantee is an independent obligation of the underlying, obligation that is guaranteed, and it doesn't go away. In a Subchapter 5, however, the trustee is granted, and the plan is allowed to do modifications to those type of loans that are secured by personal assets of the owner, which is really a remarkable step. And then finally, and I see that we're running out of time, so I'm going to hurry through this. In a normal Chapter 11, existing owners usually are left, unless every creditor is receiving all of its payment plus the interest that it's owed, or unless it's agreed otherwise, that no value is usually left over if you're an old shareholder. You lose your ownership of this unless you put new value, new money into this organization, and you get agreement. Okay, that's called the new value rule. You have to, an existing shareholder can't get anything back, is not allowed to retain its interest unless he or she puts new value in. In the subchapter 5, because it's a 3 to 5 year extension only, that new value requirement has been removed. So the shareholder stays in place, and if it meets its requirements under the plan, it is still the owner, which is obviously a humongous incentive. Next slide, please. Two important warnings here. I should say one important warning here. Applicability to PPP loans if you file bankruptcy. While I have a feeling on this, it's up in the air in the United States. I'm of the opinion, and I think Rob would probably agree because we've talked about this, that the availability of a PP loan is more applicable to an entity in bankruptcy than anyone else. It's like business interruption insurance. It's more useful and it's more important. And the Hidalgo case in Texas agrees that an entity being in bankruptcy would have no impact upon its right to receive those funds. The Cosi case, however, and it's concerning because it's out of Delaware, and as you probably know, if you file bankruptcy, that's an important jurisdiction. So many of the cases are in Delaware, has ruled the opposite way, that an entity that's in bankruptcy forfeits its rights to receive those PPP loans. I'm on the record right here. I think that would be a ridiculous outcome, but that is out there. And there's going to be an appellate court ruling on that, I would imagine.
There probably will be shortly. I fully agree with you, Larry, that the Cosi case is not very good. As a former chief restructuring officer in a 30-month free fall Chapter 11 proceeding, if I was being denied the government support at a more critical time like that, I'd probably go try to burn down Delaware. I mean,
yeah, it's remarkable too, because the judge is a Judge Shanahan that I've appeared before, and in fact, I was the chairman of the creditors committee in the Tower Records bankruptcy. That's how old I am, and he's a terrific judge, and I'm really just stupefied that he could have come to this, but it is what it is. Let's go to the next slide. Oh, this is you, Rob. So I just want to add just a few last points, just a few of the issues that you'll deal with in a bankruptcy as a healthcare company. And this is a larger conversation, but remember, if you have a provider agreement, a Medicare or a Medi-Cal agreement, and you're receiving reimbursements thereunder, the courts are split as to how those get treated. If they're executory contracts, as I told you, and the company wants to, obviously keep using them, there's a requirement to pay all of the outstanding defaults, and that can be very onerous. There are courts that are holding that those agreements are in fact not executory contracts, but they're assets of the estate, so that if you want to sell your business to someone else, you should be able to do it free and clear of all liens. Massively litigated, item. We've been through it in a large hospital bankruptcy that we're involved in, something to pay attention to. Also, my last point is just remember too that, I'm sure most of the people on this call will be very familiar with the ownership restrictions of a professional corporation that deals in the healthcare milieu. While the automatic stay can, it can give you, a breather, and it does give you a breather, the bankruptcy code will not change those obligations. So you can't change ownership to any entity that is not permitted as an owner under the California law. It doesn't change. So you can't assign equity to a creditor. That just doesn't work. So with that, I'm going to step back. Rob, if you want to finish, and then we can answer.
Yeah, just briefly, the liquidation option is obviously, if you're just at the end of the line and you don't see a post-PHE future for your business, or you just want to do something else, go farming in Massachusetts, and rather than being an ophthalmologist in Los Angeles, where one of my friends is doing just that. and you don't have enough dollars and cents to go around to pay everything off in your wind down and shutdown, then Chapter 7 liquidation is probably the way to go. If you're a big enough business, you will have Warren Act responsibilities to let your employees know. There are some kinds of debts that are not dischargeable, so pay attention to what that looks like. And then equipment leases, as Larry mentioned a minute ago, if you've got a personal guarantee, those aren't necessarily taken care of. And you know, so those are important negotiation points as you wind down. This is the least happy of the outcomes, but you know, depending on your life situation and what you see your future, going into Chapter 7 gives you, as Larry said, a certain amount of power as a debtor, even in a liquidation scenario, to work with the trustee and to muster the assets and sell them, and then you know, split the money up in an orderly fashion. So anyway, that concludes our formal presentation. You know, we hope that you've had a good morning, and that if you are in distress, that you get financial and legal help through these issues if you need it, or that you're able to knock on a couple of doors and get a little concession here and there from stakeholders around your business and get through the PHE. So with that, we'll conclude unless there's any questions coming in. Okay, so thank you very much, everyone. And if you have other questions on these issues, our contact information is on the screen, and we'd be happy to chat with you. Thank you very much.
Thanks, everyone.